Good morning or afternoon, depending on where you're joining us from today. My name is Beth Mandel, and I welcome you to today's webinar. I'm a Senior Managing Associate in the Employee Benefits Practice of Thompson Hine's Cincinnati office, and I'm joined today by my colleague, Tim McDonald. Tim is a partner in our Atlanta office. Today, Tim and I will discuss compliance considerations arising from the Supreme Court's recent and historic decision in Dobbs v. Jackson Women's Health Organization. To proactively address a question that we frequently receive, today's webinar is being recorded and it will be sent to all registrants within approximately 2 to 3 business days. During today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions at the end of the webinar as time permits, and if we catch questions as they're coming through, we may answer questions during the webinar as well. So now we'll get started as we have a lot to cover today in looking at the implications of this decision. Okay, so during today's presentation, we plan to give you an overview of Dobbs v. Jackson and where we currently stand. Talk about the employee benefit plan implications, civil and criminal penalty risk, and then we'll go through some additional employer considerations, and then, as I mentioned, we'll have time for questions. So just an overview of Dobbs v. Jackson. I'm assuming probably most of you don't need an overview at this point because it's been, all over the news, the press, basically anytime you open a newspaper or open a website, this is front and center. But on June 24th, so just about a week and a half ago, the Supreme Court overturned Roe v. Wade and Planned Parenthood v. Casey in their opinion in Dobbs v. Jackson. What this means is that essentially, whereas we previously had federal guardrails on abortion restrictions, now regulation of abortion and related services is left to the states, pending any further federal action, which in my own opinion is unlikely to happen quickly, if at all. So I would not hold your breath on that. But, we are seeing, in contrast, quick action being taken in the states. And so states are, all over the map with respect to what they're doing in responding to the post-Roe world. So we have a number of states that already had trigger laws on the books. These are laws that basically were set up and adopted to ban abortion immediately upon Roe being overturned. So certain of those laws did in fact go into effect immediately. Some will soon go into effect. Some of them require certain procedural steps to actually go into effect. And so they might go into effect 30 days after the decision or some short period of time after the decision. We have several states that still have pre-Roe bans on their books that essentially go back into effect now that Roe has been overturned. And then there are a number of states that enacted bans after Roe that, banned abortion at different levels or regulated abortion at different levels that were often enjoined by court order and that will now go back into effect. And so what we're seeing in many cases is that there might be certain states where you have all three of these, laws coming into play, and we're trying to navigate not only, what are the risks now that immediately went into effect within that state, but what is actually the controlling law when you look at all of this. So there's a lot to navigate, a lot for employers to work through. Know that everyone is on the same page and trying to get through all of this together, and it's been a quick and sort of hasty review of everything that's gone into effect. And I expect that we're likely to see ongoing litigation and challenges play out over the next few years. I should also mention, and we'll be looking at an example of this type of statute later in the presentation, that we're also seeing state action with respect to authorizing private civil enforcement of abortion bans. We're hearing lawmakers talk about, enacting laws that would ban travel, that would go after employers potentially who are providing travel assistance. So all of this, it's just things that employers are going to have to be on the lookout for the next 2 years or more. All right, so broader impact. So I think when Roe first came out, the immediate thought was, okay, how is this going to impact abortion? And definitely that has been front and center with respect to plans considering, what they need to do as far as current coverage of abortion, whether they need to restrict it, expand it, et cetera. But there are other areas that are likely to be impacted by the Dobbs decision, and that includes things like treatment of miscarriages, other pregnancy complications that arise, like ectopic pregnancies, IVF, contraception. We're seeing copycat state restrictions on gender-affirming care and other health services. Copycat restrictions have been suggested, for example, with respect to tubal ligation. So what do I mean when I say that treatment of miscarriages and other pregnancy complications might be impacted? Well, the same procedures that are used for an elective abortion are often used to treat miscarriages, to treat ectopic pregnancies. So, if a woman is experiencing a miscarriage and perhaps there's a failed miscarriage, which often occurs, there's medical intervention that's required to basically make sure that all miscarried tissue is removed from the body so that the woman doesn't experience sepsis and other complications. We know from looking at countries and other areas where abortion has been severely restricted that sometimes that can impact the ability of women to get care when they're dealing with miscarriage and pregnancy complications. There was just a situation in Malta where a woman was on vacation and did experience the beginning of a miscarriage, was unable to get treatment in Malta because they have essentially a heartbeat ban in place. So because the heartbeat of the fetus could still be detected, she was unable to get treatment and had to be flown to a different country in order to get treatment. So we could start to see increased air ambulance claims under health plans, things of that nature. IVF could be impacted because oftentimes the procedure involves fertilization of several eggs, implantation of several embryos, and then sometimes selective reduction in the event that, that maybe there's successful implantation of multiple embryos and it's not medically advisable for the woman to try to carry that many embryos to term. So we could start to see situations where it's just no longer feasible or, providers are no longer willing to accept the risk of providing IVF services in certain states. And so individuals seeking to obtain those services may have to travel elsewhere. Contraception, we're not there yet, but we are seeing some politicians suggesting that they're going to push forward with trying to ban certain forms or all forms of contraception. To the extent that we see, additional regulations being placed on that, we'll see increased interest in people wanting to travel or perhaps get access to contraception through telemedicine services. So, we do expect that this is going to have widespread impact and will affect more than just abortion. As I mentioned, this is rapidly evolving. Caution is definitely needed. Plan sponsors are going to have to regularly monitor state law. The risks are significant, and I heard someone on a call the other day describe it as, the risks themselves are significant in that risks include things like criminal penalties. However, it's unclear how often or how imminent it is that any state actors will try to actually enforce some of these laws against employers or plan sponsors. And then again, just as a caution, the guidance that we provide today could change tomorrow, could change next week, because everything is so rapidly evolving. Okay, so employee benefit plan considerations. So as I mentioned, employers are considering a range of responses, including expanded travel, expanded coverage for elective abortions, expanded telehealth services. Employers also are looking at, at the other end on restricting coverage for abortion to only what's required under federal law. Some employers are considering a blanket plan exclusions for coverage of any illegal items or services. One problem or issue that we may run into with those types of exclusions is who's administering that, right? So if you're a self-insured plan and you've retained a third-party administrator to administer your health plan, are they going to actually be doing a legal review of claims to determine legality when those claims come in, or is that duty going to fall to someone else? And then just as we talk about all of these issues, keep in mind that self-insured plans have greater flexibility than fully insured plans. So because of ERISA preemption, which Tim is going to talk about in greater detail later in the presentation, self-insured plans often do not have to worry about complying with state law that specifically regulates insurance. That either requires or prohibits specific types of coverage under insurance, whereas fully insured plans do have to worry about that, not only in the state in which the policy is issued or delivered, but also sometimes in other states where employees are covered. Okay, so federal coverage requirements, just to level set with what's still required under federal law. So there is no required coverage for elective abortions. However, we do still have limited requirements under Title VII that an employer-sponsored plan has to provide benefits for abortion where the life of the mother would be endangered if the fetus is carried to term. And then the plan also has to cover services to treat medical complications that arise from an abortion. Okay, and then we just talked about state insurance laws. So again, ERISA generally preempts as to self-insured plans, but states are going to have to worry about compliance with those state insurance laws. And that's why, when we talk about the options for expanding or limiting coverage, there are states that, place restrictions on what can be covered with respect to abortions. At the same time, there are states like Illinois that require certain coverage of abortion. And so where an employer has a fully insured plan that covers employees in both those states with kind of warring restrictions, requirements, the insurer is going to have to address those issues potentially through riders or other action. So travel benefits. So one of the responses that we've seen is that a lot of employers are interested in expanding or introducing some sort of travel coverage to provide benefits with respect to travel that's needed to obtain medical care. There are a lot of compliance considerations that go along with these travel benefits. I think when people first started talking about these travel benefits, there was a thought that maybe this would just be as simple as just, reimbursing travel receipts. But when we talk about travel for the purposes of obtaining medical care, we get into employee benefit territory that is regulated by a number of federal laws. So we have to worry about things like tax compliance, under the Internal Revenue Code, and then ACA compliance, ERISA compliance, HSA compatibility if you're offering travel coverage for medical care in connection with an HDHP HSA medical plan, and a host of other laws that apply to group health plans. So starting with taxation issues, and I should say I'm focusing more heavily on travel benefits during today's presentation because that seems to be what employers are currently focused There are other issues such as, the breadth and extent of underlying coverage for the actual medical procedures, but because we're hearing so much from employers about travel benefits, that's what I'm focusing on during today's presentation. And let me just see, I've gotten a couple questions. We will be sending out copies of the slides to attendees. You'll get those when you get the recording. And we got a question about the dollar limits that employers are applying to travel benefits. I'll talk about that in a moment. Okay, so Internal Revenue Code, Section 213D, that basically governs what is considered medical care that employers can provide on a tax-free basis to employees. So medical care includes certain transportation and lodging expenses. And in general, when we're talking about transportation, there aren't necessarily dollar limits that the IRS imposes. Reasonable transportation costs can be covered on a tax-free basis if transportation is primarily for and essential to medical care. So what does that mean? So in general, when we're talking about reasonable transportation costs, flying first class when somebody could fly coach may not be deemed reasonable. If somebody is sort of trying to game the system by scheduling an appointment in Florida right around the time of their vacation so that they can get their vacation transportation expenses covered, that is something that likely would not be viewed as travel that's primarily for and essential to medical care. Lodging expenses, when we talk about lodging expenses, those are much more heavily restricted or regulated. So unlike transportation, lodging expenses are reimbursable only if the expenses are incurred primarily for and essential to medical care, and the medical care is provided by a physician in a licensed hospital or a medical care facility related to or the equivalent of a licensed hospital, and there is no significant element of personal pleasure, recreation, or vacation. So really the complicating factor there is that the medical care has to be provided by a physician in a licensed hospital. We know that, some of these services that we're looking at, like certain types of abortions, may not always be provided in a licensed hospital or a facility that's the equivalent of a licensed hospital. They may not always be provided by physicians. So in some cases, nurse practitioners, registered nurses, may be assisting or providing services. Additionally, unlike transportation, there are dollar limits on what can be reimbursed for lodging on a tax-free basis. So lodging expenses generally are limited to up to $50 per night per the individual receiving treatment. And then there are some situations where an additional $50 can be provided for a companion. For example, if the individual receiving treatment is a minor and a parent needs to travel with that individual. Anything else, so any travel benefits that don't qualify as medical care, that don't meet those standards, generally have to be treated as taxable income. Okay, so then we get into all of the other group health plan compliance issues that I mentioned. And as I noted, when we think about what is a group health plan, the definition of group health plan is fairly broad, and it does encompass amounts paid for transportation for medical care. So if you are providing a benefit that is, structured to provide reimbursement of transportation for medical care services, as opposed to just like a general travel benefit where you're giving people $4,000 a year to use for travel for whatever purpose they want, and you're not, asking them to substantiate why they're traveling. If you're reimbursing travel that is tied to medical care, most likely you've created a group health plan. And what that means is that there are a number of federal laws that you have to think about and consider in designing that plan so that you're in compliance. So starting with the ACA imposes certain coverage mandates on group health plans, including the requirement to cover certain preventive care without any member cost share. if you are creating a standalone travel benefit and that benefit just reimburses individuals for travel and doesn't cover those required preventive care benefits or doesn't meet other ACA coverage mandates, then potentially you have a non-compliant group health plan. And that's important because non-compliant group health plans are subject to an excise tax of $100 per day per participant. So those excise taxes can add up quickly. Now, we do have some exceptions to this ACA requirement and some ways of, pairing benefits with ACA compliant medical plans so that you can comply with the ACA. So we're going to go through some examples of how a travel benefit could be designed that would provide compliance with the ACA in a moment. Other considerations, so ERISA, so this type of benefit is going to be an ERISA governed benefit. You'll need a written plan document and summary plan description. You'll have to think about ERISA compliant claims procedures and how you're going to administer those. And then plan administrators administrating ERISA plans have a fiduciary duty under ERISA to administer benefits in compliance with applicable law, also in compliance with the terms of the plan. But for this context, we really are concerned about that applicable law piece because, as I noted, applicable law is all over the map. And it is possible that someone could potentially bring a ERISA fiduciary claim against a plan that they believe is administering benefits in violation of applicable law. HSA compatibility. So as I mentioned, if you are offering travel benefits and you have an HDHP plan paired with an HSA, there's the potential, depending on how those travel benefits are structured, that they could render an individual ineligible to contribute to the HSA. So again, there are ways of addressing this. We'll go through that when we look at the 3 examples. HIPAA privacy and security, always something that has to be considered whenever dealing with a group health plan benefit. In this case in particular, to the extent that we're dealing with abortion care and similar services, we're dealing with services that are likely to be very sensitive. There are a lot of feelings across the board about these services, and so privacy concerns will sort of be extra heightened in this context. Mental health parity, so I'm not going to go into detail about this. There's a possibility that if you're offering travel for reproductive health care services only and not offering travel for mental health care and substance use disorder services, that potentially could amount to a non-compliant, non-quantitative treatment limitation. If you're thinking of going down that route, I would suggest, conferring with counsel about that to determine what the potential risks are there. And then finally, COBRA, we need to always be concerned about, how we're going to comply with COBRA whenever introducing new group health benefits. So do you need to actually offer COBRA? Are the benefits being offered under a plan for which you're already offering COBRA if a COBRA qualifying event occurs? Issues to consider depending on the plan design. So let's look at 3 common plan designs that employers are considering. The most conservative, and I would say the option that most of the employers who we're speaking with are considering, is to expand travel benefits under an existing major medical plan. The benefit of taking this approach is that, as I said, it's the most conservative, so least risk from a benefits compliance standpoint, from a federal traditional benefits law standpoint. It's an ACA compliant plan design because essentially you're just offering additional travel benefits under a major medical plan that already meets those ACA or should be meeting those ACA coverage requirements. The TPAs and insurers who are administering the medical plan are already processing claims, tracking deductibles, etc. So they should be able to easily comply with ERISA claims and appeal processes. They should be able to theoretically, easily track the deductible to make sure that if it's a high deductible health plan, you're not providing coverage prior to the participant meeting that deductible. It's going to be fewer issues that the plan sponsor has to consider from a HIPAA and general privacy concern perspective, because for the most part, claims will be routed through that TPA or insurer. The employer shouldn't be getting a lot of PHI related to those claims, and so there's less risk from that perspective. And there should already be a COBRA structure in place, ERISA documentation in place that the employer can rely on with respect to those benefits. Additionally, for ERISA compliance, you have to think about filing 5500s. If you're just adding this benefit to an existing major medical plan, you're likely already filing a Form 5500 for that plan, so you don't have to file an additional Form 5500 for these travel benefits. So there are some drawbacks to this approach, though. It could result in additional fees. It's dependent on the TPA's or the insurer's willingness to administer the benefits. In general, what we've seen is that most of the larger TPAs who play in this space are, they've been pretty willing to accommodate employers and expand travel benefits, and are working on some standard packages related to expanded travel benefits. It's going to be trickier with respect to fully insured plans who have to really worry about compliance with all of those state laws. In most cases, coverage when you're offering it under a major medical plan, so you're only going to be able to cover employees or dependents who are already enrolled in the major medical plan. So you're not going to be able to extend just coverage of travel benefits to people outside of the major medical plan. And in most cases, the TPAs and insurers who are administering this benefit are limiting it to travel that is related to medical services that are already covered under the plan. So if, for example, your plan only covers, therapeutic abortion in the event that the mother's life is in danger, and you're looking for a way to cover travel for elective abortion, this may not be a viable option for you unless you are able to and willing to expand coverage under your group health plan to also cover elective abortions. And then mental health parity compliance will need to be considered with respect to this option as well. Let's see. Okay, we did get a question. Can ERISA plan be sued for possible violation of state law, or is it just a violation of federal law? In general, yes. Tim will talk more about, what ERISA preemption looks like later on in the presentation. But in general, yes, the risk of lawsuits under state law is still a possibility. Okay, so travel benefit design option 2. This would be something that could be an option for employers who perhaps offer a fully insured group health plan, and their insurer is not willing to expand travel benefits under that fully insured plan, but the employer still wants to take a somewhat conservative approach from an ACA standpoint. Under this approach, what an employer could do is essentially set up a health reimbursement account that is integrated with that major medical plan. What we mean by integrated mainly is that eligibility would need to be limited only to individuals who are actually enrolled in that major medical plan. And for HSA purposes, to the extent that the major medical plan is an HDHP plus HSA, the plan sponsor is going to have to, figure out a way to administer the HRA on a post-deductible basis so that they're not reimbursing travel expenses before the employee has met their deductible under that HDHP. The pre-HDHP reimbursement of travel expenses in this scenario basically would make a participant ineligible to contribute to their HSA, which is a result that I think most employers would try to avoid. So one of the drawbacks with this type of approach is that in most cases, plan sponsors are going to be in a situation where they'll have to administer this in-house unless they can find a TPA who's willing to administer this HRA for them. Now, it's possible that there could be TPAs who start to provide services in this space, and in fact, we are seeing some indication that some of the fertility startups like Carrot Fertility may be trying to figure out a way to administer travel benefits for employers related to fertility, abortion, other services. But right now, unless you can find maybe a traditional HSA, a traditional HRA or maybe FSA administrator who's willing to administer some sort of HRA travel benefit for you, employers would be faced with administering this in-house, which means you're reviewing claims, you're getting PHI, you are having to apply a HIPAA or a ERISA compliant claims and appeal procedure, etc. So a lot more administrative burden with this approach. Then we have design option 3. I would say that, design option 1 and design option 3 tend to be the most attractive to employers. Design option 3 is essentially that you design the travel benefit as an accepted benefit. So there are certain types of benefits known as accepted benefits that don't have to meet those ACA coverage mandate standards. So if you design the benefit as an accepted benefit EAP, Employee Assistance Program, for example, then you don't have to worry about ACA compliance from the coverage mandate perspective. You don't have to integrate or pair the EAP with your major medical plan. In fact, you can't do that with an accepted benefit EAP. So you have the ability to provide benefits to a broader crowd of individuals than just those employees and dependents enrolled in the medical plan. So let's say you have a lot of employees who waive your medical coverage and take their spouse's coverage. This may be a more attractive option. Eligibility, you have greater flexibility to also limit eligibility to certain classes of employees or dependents. And also you can use this benefit to cover travel for medical services that aren't covered under the medical plan. So if you wanted to provide coverage for travel related to elective abortions, but your major medical plan doesn't cover elective abortions, this might be the option that you look at. Another attractive point of this design is that it does not impact HSA eligibility. So you can provide pre-deductible coverage under an accepted benefit EAP without making someone ineligible to contribute to an HSA. There are some cons or risks with respect to this approach. So, we currently lack very in-depth guidance on what's considered an accepted benefit EAP. So when we think about accepted benefit EAPs or employee assistance programs, we're generally thinking about, those traditional, employee has access to 3 to 5 counseling sessions per year per program. It's not clear that the IRS intended accepted benefit EAPs to encompass programs like this that provide $4,000, $2,500 of travel reimbursement related to medical care. One of the requirements for a program to be an accepted benefit EAP is that the program cannot provide significant benefits in the nature of healthcare. And that is really the piece that we lack clear guidance on. So would a travel benefit related to medical care, would that be considered significant benefits in the nature of healthcare? So there's some risk in this approach. Now, that said, the agencies have not really been heavily policing accepted benefit EAPs in the recent past, and we've seen employers taking more aggressive approaches with what they're characterizing as accepted benefit EAPs. It is possible that we could start to see the agencies crack down on these types of benefits, and if so, employers who have implemented broader accepted benefit EAPs will likely need to pivot, or at least consider pivoting. But for now, we think this remains a possible option. You know, not without risk, but it is out there and could be a good option for employers who are seeking to do more than what they can do under their major medical plan. As far as administrative burden, we have the same issues here that I talked about with respect to the HRA. So unless the employer can find a TPA or other third party to administer this benefit, you're going to have to administer it in-house. So that means, you know, dealing with ERISA claims procedures, HIPAA compliance, handling PHI, and then regardless of whether you are administering this solely in-house or retaining a third party to administer this, you'll need to adopt additional plan documentation for ERISA compliance purposes. If you have a WRAP plan, we would probably recommend, you know, wrapping this in as part of your WRAP plan, but still you'll need additional documentation describing the benefits, possibly an additional summary plan description. And then COBRA and HIPAA compliance have to be addressed. For COBRA, oftentimes what we see people doing with accepted benefit EAPs is just automatically extending coverage during what would be the COBRA coverage period. But sometimes, you know, they prefer to make employees affirmatively elect COBRA. So there are different options for dealing with that. Definitely speak with counsel if you're considering this. And then other design considerations with respect to travel benefits. So we're seeing people struggle with, you know, do they offer broad travel assistance? So just travel assistance in general with respect to any medical care that someone's unable to obtain within a 100-mile radius of their home, or are they tailoring the benefit to specific services such as reproductive health care, gender affirming care? There are, you know, pros and cons to that. It's possible that employers who are going the broader travel assistance route will face less scrutiny from, you know, the anti-abortion lawmakers and activists who are, you know, potentially looking for employers to target to the extent that employers are, you know, offering abortion-specific coverage. And then other conditions that will potentially apply to coverage. This is where we get into those dollar caps. So someone had asked about, you know, they've heard that a lot of employers are offering travel support up to $4,000. Where does that dollar limit come from? Well, it doesn't come from the Internal Revenue Code, for example. So I think probably where that number came from is that Amazon announced that they were going to cover travel up to $4,000 per year. And I think following that announcement, a lot of companies just sort of looked at that as sort of a benchmark, but it's not a legal benchmark. So those kind of, you know, dollar caps, aside from the lodging cap that we discussed of $50 per night, the, you know, annual caps on travel coverage, lifetime caps on travel coverage, those are kind of, you know, plan design considerations that employers will have to think about as ways of managing overall plan costs, etc. Other things to think about, you know, are you going to cover travel only if it's only if the underlying services cannot be obtained within the state due to state law? Are you covering travel if the participant can't obtain services within a 100-mile radius? How are you going to administer that? Are you just going to have the participant attest to that? Or are you expecting somebody to look into that to actually see if services potentially are available? Other issues to consider, like lifetime or annual dollar caps, pre-certification requirements. So there are a lot of nuances that we get into once we start actually trying to craft these benefits. Okay, so switching to civil and criminal liability. So, one question that we keep getting is, can an employer or a plan administrator be held civilly or criminally liable if they reimburse travel costs for an employee who's living in state A, for example, Texas, that bans abortion, and that employee travels to state B to obtain an abortion? And unfortunately, right now, we don't know. We expect that this issue, along with several other issues, are going to be litigated over the next several years. We do expect that there will be some effort at some point to try to target employers who are providing this type of assistance. So let's take a look at some of the an example of a state law or state laws that employers might be facing. So looking at Texas. So at the very beginning of the presentation, I talked about how a lot of states have multiple bans on the books. And Texas is an example of that. They've got a pre-Roe ban that criminalizes abortion and provides that whoever furnishes the means for procuring an abortion, knowing the purpose intended, is guilty as an accomplice. They've got a trigger law on the books that also is a near complete ban on abortion with limited exceptions, and it imposes criminal penalties on the person who performs, induces, or attempts to induce the abortion, doesn't impose penalties on the woman who seeks abortion, and the statute itself doesn't explicitly address aiding and abetting with respect to other individuals who might assist the woman in obtaining an abortion. But the Attorney General of Texas has suggested that he potentially would try to use this law to go after employers who are aiding and abetting in abortions by providing coverage or assistance to women. Now, he's said that in press conferences or news interviews, it's unclear how much of that is bluster, how much of that is reality, but it's not outside of the realm of possibility that a creative prosecutor, that a civil complainant could try to go after employers for activity related to providing coverage in connection with abortion, whether that's coverage of the service itself or travel coverage. We also have the Texas Heartbeat Act, which was very highly publicized last year. This is, so when we hear heartbeat acts, typically what we're talking about here is 6-week ban, because oftentimes around the 6th week is when a heartbeat is detectable. So these types of bans usually prohibit abortion after the detection of a heartbeat. And the important part about this act is that, actually, let me go back. It includes a private right of action that allows any individual other than an officer or employee of the state to bring a civil action against any person who, key phrase here is, knowingly engages in conduct that aids or abets in the performance or inducement of an abortion, including paying for or reimbursing the cost of an abortion through insurance or otherwise, if the abortion is performed or induced in violation of the Heartbeat Act, and can also bring a civil action against anybody who intends to engage in that conduct. So, I think that at this point, a fair reading of that statute is that this would only be applicable to employers who are potentially paying for or reimbursing abortion costs that are related to an abortion that's performed in Texas in violation of the Heartbeat Act. But again, I wouldn't be surprised if somebody tries to use this to sue an employer who is providing travel assistance to help an employee travel from Texas to, for example, Illinois to obtain an abortion in Illinois. I also will not be surprised if we see states like Texas and others who are heavily regulating abortion start to adopt laws that specifically target that provision of travel assistance to individuals who travel out of state to obtain an abortion. Again, we are expecting that all of this will be challenged and will be litigated over the coming years. Okay, and I'm going to turn things over to Tim at this point to talk about ERISA preemption.
Thank you, Beth. And before I move on to preemption, I just want to pick up on the last point that Beth talked about, which is people asking how likely is it that these things will be enforced? If you go back one slide to the last one that Beth was working on, that law is not enforced by, for example, the Attorney General of Texas. It's enforced by your neighbor. It's enforced by somebody who lives across the state in a town you've never heard of. Any individual in the state under Texas's law can bring that. So when you think about your risk calculus, you're not thinking about what will a district attorney do or what will an elected official do, someone who might have to balance various interests. It's literally anybody with whatever view they may have personally who can bring that claim. There have been two not at the merit stage cases that have already gotten before the Supreme Court about whether or not a law can be structured in that way. This is basically an attempt to allow enforcement by getting around the state action doctrine, where the state enforces the law, and the Supreme Court and Congress use the state's enforcement as the hook to regulate the action. But that is still a issue that is far from decided, and that new concept, that new way of structuring a law is being copied in numerous circumstances in different states as we go forward. Now I'll get back to preemption. Most of the people on this call probably have a good understanding of what ERISA preemption is. And those who practice in this area seem to reflexively think that state law is preempted. That's just the way we've been brought up. And that's the way that it seemed ERISA worked for the longest time in the 80s, 90s, and the O's perhaps. But that is not the way it works now. So let me go back to the basics for a second and then get to where preemption is today under ERISA. There are three interlocking parts of ERISA statute, which talks about preemption. One, section 504A, or the US code section is 1144A, which says that ERISA supersedes any state laws insofar as they may now or hereafter relate to any employee benefit plan. Numerous judges have noted that the relate to standard is almost limitless. The exceptions are laws which regulate insurance. That's why insured plans sometimes are subject to various state laws, whereas self-funded plans are not. And then the deemer clause under ERISA, which says you don't treat a self-funded plan like it is being registered as the business of insurance, even though it may be providing benefits like an insured plan. When you put those three things together, you basically get the distinction that Beth was talking about earlier, where fully insured plans are more heavily regulated by states and self-funded plans are effectively not. You can go to the next slide, please. As I mentioned, ERISA preemption has flowed and ebbed, and we are at an ebb at this point. I'm going to just pick the last case because I could spend more than the 1 hour just on a history of ERISA preemption. But 2 years ago, in Rutledge versus Pharmaceutical Care Management Association, the Supreme Court passed on an Arkansas law that was aimed at regulating pharmacy benefit manager pricing practices. So if you think about it and step back for a minute, to a lot of us, that might seem like something that's right in the wheelhouse of ERISA. Every plan, it seems these days, when you talk about health plans, covers medical prescription drugs. And so this kind of regulation seems pretty obvious. But when all it is doing is dealing with the cost and not the structure or the delivery of the benefit beyond the cost, the court has drawn a line and said that's not preempted. So when we think about that reflexive belief that I mentioned a little while ago, that in this world ERISA preempts, it's not so clear anymore. And Rutledge is just one example of it. When you take Rutledge and you now think, if you go to the next slide, how does that apply in this circumstance, or how does a court that thinks that way apply in this circumstance? If there's a state law that says no benefit plan may do X with respect to abortion, that's likely to be preempted. If there's a state law that says travel expense reimbursement is prohibited under these circumstances, but it doesn't talk about benefit plans or talk about any other way that you do it, that may not be preempted. And the state law criminalizing or facilitating the use, including travel, is probably not going to be preempted. So is that the only source of preemption, or is there some other way that preemption can come into play? The ERISA preemption is actually one of two types of preemptions that the Supreme Court and the Constitution provide for. The first one, ERISA preemption, is a type of preemption called field preemption. ERISA is one of only 3 laws in all of the federal code that has been deemed to be so comprehensive that it does not permit a state to regulate in that area, even if ERISA itself doesn't say anything on a particular topic. The other type of preemption, which is more common, is conflict preemption. And that is where you simply cannot comply with one law under state law and the federal requirement on the same topic at the same time because of the conflicting obligations. So if you have a circumstance where the law does not specifically mention a benefit plan and you are not dealing with changing the structure of a benefit plan, and ERISA preemption may not apply, this type of preemption may apply. So an example, the most recent case, again, I've just plucked as opposed to going through a history of this, Kansas versus Garcia, in terms of the regulation of immigration. Kansas had a separate prohibition on providing a false social security number and employment-related documentation. While employment-related documentation and the provision of information is very heavily regulated by our federal immigration laws, the Supreme Court said, you know what? These two really don't conflict. And so Kansas can regulate here, even though there's a wealth of federal regulation. So in this type of preemption, you really need to be in a position where the state law puts you in a position where you cannot comply with that state law without actually violating federal law. So what are some non-ERISA potential grounds for supremacy clause preemption? Justice Kavanaugh actually gave employers a little bit of a helping point in his concurrence in Dobbs. He went beyond the questions that were at issue, probably anticipating some that would be on the minds of folks listening today, and said, it is pretty clear that a state cannot prohibit travel from one state to another to seek abortion care. And if you take Justice Kavanaugh's view on that at face value, you add it to the 3 dissenting views, assume that our new Justice Jackson is going to vote the same way as Justice Breyer, which is probably pretty reasonable. It is also likely that Chief Justice Roberts would agree with Justice Kavanaugh's view based on some of his prior writings. You have 5 votes that would say that a state cannot impose the type of travel ban that some of the states are talking about. That sounds like a nice, neat, straight line, but you don't even have a single court that's had to cross that bridge yet. That's just thoughts by me in terms of how this may turn out based on Justice Kavanaugh's concurrence. Beth, if you can move to the next slide, please. So that's something to watch as these legal challenges are lobbed. Beth mentioned earlier the Pregnancy Discrimination Act. Again, if a state law prohibits something that you can do under the Pregnancy Discrimination Act, you may have grounds for a supremacy clause or conflict type of preemption. On the next slide, these are the same 3 scenarios that I had a couple slides ago, but this is now thinking about it under conflict preemption. State law mandating restrictions on benefit plan coverage, that's probably going to fail under ERISA preemption. The state law prohibiting reimbursement of travel expenses may not really conflict with federal law unless there is a federal law that requires that kind of reimbursement. And the same thing with respect to the state law with respect to facilitating the use of abortion services, including travel. That's an area where the Privileges and Immunities Clause may come into play in terms of somebody having a right that would be in conflict with this state law, and the federal right to travel would be paramount. There are some additional employer considerations that are a little bit more on the employment side than the ERISA side. We can move up a couple of slides. Again, revisiting the Pregnancy Discrimination Act. If you look at the second bullet point, that law looks for parity for pregnancy-related leaves on the same terms and conditions as others who are similar in their ability or inability to work. The way the court has applied this is basically if there's a pregnancy leave issue, they look at, for example, what would have happened if you were on workers' compensation leave? Would you have the same rights that you do in this circumstance under this policy because you're pregnant? And so it is basically bringing parity with other types of leave when you are relying on pregnancy as the reason why the leave is taken. In the next slide, we have Title VII, which takes or prohibits adverse actions against employees. That's pay, employment, etc., promotion based on decisions relating to abortion. That can be either foregoing or seeking one. Obviously, the potential for harassment in this area is different than what we normally think about in terms of other types of harassment. But given that the views of people from both sides of the spectrum are deeply held, it's not at all beyond the realm of possibility that you could have a claim like that. Under the Americans with Disabilities Act, as dealt with on the next slide, what you're really looking for there is there anything about the physical condition of someone that involves a major life activity or a major bodily function that is substantially limited by, for example, a pregnancy-related complication. In that circumstance, even if you have a leave that maybe tops out at a few weeks or family medical leave at 12, it's possible that an Americans with Disabilities Act leave of a longer duration could be required. And so that needs to be considered. The next slide deals with a host of things that you need to think about when you are putting voluntary paid time off policies in place for seeking abortion services. These are really no different than what you have to do in laws that are, in policies that are not specific, but more broad leave policies. But they're things that you should really be thinking about when these policies are being put into place, because you can have unintended consequences from the unique circumstance of the travel and the type of benefit that you're dealing with here. Finally, privacy-related issues. There have been some warnings about enforcement actions and seeking user data. There's actually on a Bloomberg article today about how you can construct a plan like this using the least amount of print. So there's less data around for people to come to later. Again, the general HR data is normally not protected health information. When you start to look at information related to plans, that is really the wheelhouse of what you're talking about under that law. And finally, when you are dealing with concerted activity under the National Labor Relations Act, which seems to pop up everywhere you don't expect it to be, individuals talking about these policies, how they should be developed in a collective basis, could give rise to a National Labor Relations protected circumstance, even where there is no union currently present. There's one question about a fully insured plan and coverage based on the state the plan is written in or the services are provided. I may be misunderstanding the question, but I think the way to look at it is what state would think they are regulating the conduct as opposed to the services. And the state will probably look at the conduct that takes place either by whether the care is delivered there or whether the person who is subject to the care is from their state. Beth, at this point, I'll hand it back to you.
I was muted. I'll just add, Tim, on that question that, you know, for a fully insured plan, in general, often the insurance policy is going to be governed by the state in which the policy is issued or delivered. So if you have a policy that's issued by Blue Cross Blue Shield of Wisconsin to an employer in Wisconsin, you know, likely primarily governed by Wisconsin law with respect to the content of that policy. But the policy may have to be interpreted with the state law of other states in which services are being delivered. And that's why we often see state-specific riders that attach to insurance policies. But again, that's a very complicated issue that people are working through at this very moment. So a lot of insurance regulators are still, you know, unclear as to how they're going to deal with some of these conflict of law issues. So I think we've addressed all of the questions. Thank you very much, Tim, for partnering with me today on this. And thank you to all of you for attending. As I mentioned earlier, we will be sending out a recording of the webinar as well as copies of the slides to registrants. If you have any questions that you were not able to get answered, please definitely reach out to your Thompson Hine attorney. If you aren't currently a client, please feel free to contact me or any other member of the employee benefits group at Thompson Hine, and we're happy to discuss available options with you and route you to the right person. Thank you very much, and please enjoy the rest of your day.